Ladies and gentlemen, I'm pleased to welcome you to this lecture series titled Know Your Right. The purpose of these lectures is to educate and enlighten Nigerians on their basic rights as guaranteed under the laws. We all know that knowledge is power, and with our power, we can turn our society into an orderly and better place to live. A place to live peacefully with our children and children's children, a society where the fundamental rights of every Nigerian is respected. In this various lecture series, we shall be talking about the several aspects of your rights as guaranteed under the law. This will include what the law says about your rights as a tenant. Once you know your rights, nobody can deal anyhow with you. And if you are a landlord, what are your rights as a landlord under the law? If you're an employee working in the private or public sector, what are these rights and entitlements which the law has guaranteed you as an employee? Do you also know that you have some fundamental rights under the Nigerian Constitution which nobody is allowed to trample upon? Do you know that you are entitled to a public apology and monetary compensation if your fundamental human rights have been breached? These are the things we shall talk about in our lecture titled Know Your Fundamental Human Rights under the Nigerian Constitution. Again, if you have a police case, what are your rights? Are the police allowed to detain and torture their suspects? Are they allowed to force you to make confessional statements or sign an undertaking? When and how can the police search your home and seize your properties? These and many more are the topics contained in our lectures titled Know Your Rights Against the Police and in the Courts in Criminal Matters. We also have a lecture series where we shall teach you about your civil rights against other people. It is not everything that must end up with the police. What is your civil rights if somebody assaults you or damages your property? What can you do if somebody defames your character? What is nuisance? How can you seek a legal remedy for trespass to your property? When and how can you recover money owed you by others? How can you enforce your civil rights without going through the police? Watch out for these and many more interesting topics under our lecture titled Know Your Civil Rights Against Other People. Lastly, we should teach you about how to safely buy landed properties anywhere in Nigeria without getting into problems. This is under a lecture titled Know How and Where to Safely Buy Landed Properties in Nigeria. These are all lectures that will blow your mind. Permit me to inform you that the Know Your Right lecture series are sponsored by the Public Enlightenment Campaign Organization, PECO. You can find information about this NGO at www.peco-ng.org. Now, ladies and gentlemen, join me to welcome our lecturer who shall be teaching us today. Let's put our hands together to welcome Barrister Manuel Akinshola.
Thank you, ladies and gentlemen. I welcome you to this lecture on Know Your Rights as a Tenant, Volume 2. Know Your Rights as a Tenant, Volume 2. In this Volume 2, I shall discuss topics like your right to basic amenities, your right to quiet and peaceful enjoyment of your apartment, and etc. And I will talk on arrears of rent and its legal implications. Also, I will talk about renovations and the nature of your tenancy. Like you have been told, the purpose of these lectures is to educate you. Therefore, though I'm a lawyer by profession, I will refrain from speaking big grammars or using confusing legal terminologies. I will also not be citing cases or too many sections of the law, because all I want is for you to just understand the basic principles of your rights as a tenant. And then you can contact your lawyer if you feel you need more clarifications on your case. Thank you, and I welcome you to the world of knowledge. Thank you again. Now, let's start. This is Chapter 1, and here we shall be talking about your right to basic amenities. Your right to basic amenities. As a tenant, you are entitled to some basic amenities in your apartment. These basic amenities are the minimum facilities which each category of apartments must have. Any apartment that has these basic amenities is standard. Any apartment that lacks even one of these amenities is regarded as substandard. Now, I will tell you what should be the basic amenities for each type of apartment. The first one is what should be the basic amenities for a room or a room and parlor. If you occupy a room or a room and a parlor in a tenement building, you are entitled to enjoy the following amenities. Number one, your room should not be less than 11.2 square meters, that is the usual 10 by 12 feet in dimension. Number two, your parlor should not be less than 14 square meters, that is 12 by 12 feet. Number three, the kitchen, toilet, and bedroom should not be shared by more than 6 to 8 rooms. Number four, the floor of your room should be finished with cement. The floor of your room should be finished with cement. Number five, power supply to the building should be from the national grid. Number six, there should be water for the premises. It may be from the mains, that is the water corporation or government body. It may be from the borehole, from a well, or any other good source. But at least there should be water for the building. Those are the basic amenities for a standard room or a standard room and parlor. Then, what are the basic amenities for a standard flat? If you occupy a standard flat, you are entitled to the following basic amenities. Number one, your sitting room plus dining room should not be less than 14 square meters, that is the normal 12 by 12 feet in dimension. Number two, the rooms should not be less than 10 by 12 feet in dimension. Number three, you should have a kitchen with or without a store. Number four, there should be water closet flush toilet, that is the one popularly called WC toilet in the apartment. Number five, there should be a bath or shower room. Number six, there must be power supply from the national grid. Number seven, there must be water supply from the water corporation or any other good source like borehole or well. But most importantly and preferably, this water should run inside the apartment. Then number eight, your flat should also have terrazzo flooring in the sitting room and in the kitchen. Then it must have PVC tile flooring in the bedroom. Those are the basic minimum amenities for a standard flat. Lastly, let's talk about the basic amenities for a duplex or a house. If you occupy a duplex or a standard house, whether it is detached or semi-detached, you are entitled to the following amenities. Number one, a living plus dining room. Number two, standard rooms must not be less than 12 by 12 feet. Number three, a kitchen and a store. Number four, WC flush toilet on all the floors. So if you have 2-3 floors, there must be WC flush toilet on each of the floors. Number five, baths or shower rooms. Number six, water supply from the mains or any other good source, and preferably this water should be available inside the duplex or house. Number seven, there must be power supply from the national grid. Number eight, there should be terrazzo flooring in the living and dining room, in the kitchen, toilet, and bedroom, and on the stairways. Please note, terrazzo flooring in the kitchen, toilet, and bedroom, and on the stairways. Then, number 9, there should be PVC flooring for all the bedrooms. Those are the basic amenities for a duplex or house. All these amenities I have mentioned are the minimum which an apartment should have for it to be regarded as standard. Your apartment may have more than this, it is a bonus. If your apartment does not meet up, it is still an accommodation, but it may be regarded as substandard. Please note that these standards may or may not be expressly prescribed in any law, but it is generally accepted as a common standard all over Nigeria. So you can use these requirements to measure the apartment you are occupying or the one you want to let to decide whether the apartment is up to standard or not. In addition to the amenities I have listed above, you are also entitled to good ventilation as provided for under the applicable sanitary regulations, irrespective of whether you occupy a room, a flat, a duplex, or detached house. Each building is required to leave a space of at least 6 feet to the fence, or at least 12 feet to the next building if there's no fence. This is to allow for the free flow of air. If your apartment does not have such space or more, then it is not standard. You are also entitled to a clean and neat environment and surrounding. It is the duty of every property owner to make provisions for proper drainage from all the bedrooms and kitchens of the building. The landlord is also obliged to make adequate provision for a free and clear drainage in front of the building so as to prevent stagnant waters from mosquitoes or other insects. Your landlord is obliged to put in place provisions for waste disposal. But if your landlord does not live in the building, then these duties fall on you as the occupier. Where any of your rights under this topic is being infringed upon, your remedy will depend on the applicable laws. For instance, if any of the basic amenities is lacking, your remedy lies in the amount of rent payable. This means that the amount chargeable as rent may be reduced in line with the amenities that are lacking. If you are just moving into an apartment as a new tenant and some of these amenities are lacking, you may use the absence of these amenities to negotiate a reasonable rent to be paid by you. Where again, for instance, you are not having good ventilation or good toilet and bathroom, or your environment is being messed up by others, you are entitled to notify the sanitary department in your local government for the necessary legal action to compel your landlord or your neighbors to make the required adjustments. Another point you must note, most especially in this era of building collapse, is the soundness of the structure itself. If you suspect that the structure of the building you occupy might be weak, is sinking, or is likely to collapse, please notify your State Ministry of Physical Planning and Development. You may also report to your local government town planning authority. No need to be sentimental about this. Remember that your life and properties are involved. If you don't want to be disclosed as the complainant, you may write as anonymous. After inspections, the appropriate authority may mandate your landlord to carry out some structural repairs that will guarantee the safety of the property and its occupiers. Now, let me make this point here, because somebody may ask you, what is the essence of knowing these basic amenities? This knowledge is very important if the issue of rent increment arises. It does not matter where you live in Nigeria. You are entitled to approach the court if you believe the rent increase by your landlord is not commensurable with the amenities available in the apartment. This does not mean that you are fighting the landlord. No. The court will look at the presence or absence of these basic amenities to arrive at a decision. In the case of Lagos State, however, the tenancy law of 2011 has made a beautiful provision for you on what to do if you believe that the increment of rent by your landlord is not reasonable. Let me keep you in suspense and keep the good news for you until later in this lecture. But let me just inform you that if your landlord increases your rent wherever you live in Nigeria, and I repeat, wherever you live in Nigeria, and you believe that the increment is not justified in view of the standard of the apartment, then you have a legal course of action open to you. This is the law. Now, let me talk about the issue of disconnection of power or water supply to a tenant's apartment by a landlord. I must talk on this very crucial point because it has become a rampant practice amongst landlords all over Nigeria and especially in Lagos State. Some property owners are in the habit of disconnecting power or water supply to a tenant's apartment, particularly when they want to forcefully eject that tenant. Some do it under the excuse that the tenant owes house rent. This is an illegal act. This is an illegal act. All over Nigeria, it is recognized as wrongful to disconnect power or water supply to a tenant's apartment under any guise whatsoever. It makes the property owner liable in a criminal action with punishment ranging from payment of fine to a term of imprisonment. This is one of the actions which can bring about a breach of the public peace and for which the police are entitled to be invited to take the appropriate measures. This act of disconnecting water or power supply may also constitute trespass in certain circumstances. The property owner may be liable in a civil action to pay damages to the tenant for trespass. It does not matter that he is the owner of the property. I know some of you will say, how can a landlord be liable for trespass on his own property? It is possible. The landlord's right over the property is not absolute. It is not absolute, so long as he has put in a tenant. The law is that a tenant who lets an apartment is entitled to his privacy and the right of possession, and any contrary act is regarded as trespass against him. Nigerian courts have always maintained that property owners must not derogate from the rights of their tenants or resort to self-help in ejecting a tenant. And where this happens, they are liable to pay damages to their tenants for the illegal act. Besides, the landlord is not PHCN, he is not Water Corporation, he is not an official of these corporations, hence he is not entitled to undertake the disconnections. If he believes that the tenant has accumulated power or water bills, the worst the landlord can do under the circumstances is to report to the appropriate agency for the necessary action. So, tenants, be on the lookout against these illegal acts. Resist it by all legal means. Please don't fight your landlord or even engage in verbal assault. Just consult your lawyer and your lawyer will know the appropriate legal action to take. The same principle applies to landlords who lock up the entrance door, the toilet or bedrooms or kitchen of their tenants. This is more common in tenement building where the toilet, bedrooms or kitchens is not inside the apartment. Some landlords are fond of locking up the toilet or bedroom of their tenants on flimsy excuses. This is wrong under the law because the tenant is entitled to enjoy these basic amenities in the building. Let me inform you that specifically in Lagos State, under the tenancy law, it is wrong for the landlord to prevent the tenant from enjoying the common amenities in the building. These common amenities have been listed as including the veranda, the balcony, the kitchen, the toilet, etc. I will talk more about this later on in this lecture. This same principle applies throughout Nigeria. It does not matter that there is no specific tenancy law in your state or local government. The common law applies all over Nigeria. And under the common law, it is wrong for the landlord to deny his tenant the enjoyment of the basic amenities of his apartment. So, where this happens, the tenant is entitled to remedies under the law. This is the law. Now, let me go to the next topic, and this is about the obligations of both the landlord and the tenant. The tenancy law of Lagos State introduced some other innovations as far as the landlord and tenant relationship is concerned. It has specifically listed the obligations of a tenant to his landlord and that of the landlord to his tenant. Let me list those obligations as follows. Number one, I will take your obligations as a tenant to your landlord. Number one, you must pay the rent as agreed and as at when due. Number 2, you must pay all charges that are not payable by the landlord. That is, your water rate, your electricity bill, the cleaner's fee, your waste disposal bills, and all other service charges where applicable. Number 3, you must keep your apartment and the premises in good and tenantable state. You must not willfully or negligently damage your apartment or any part of the premises, e.g., the doors, the windows, the accessories, the walls, and all other parts of the apartment or the building. The only exception here is what we normally call the reasonable wear and tear weather rule. That is, the normal wear and tear from daily use. Number 4, whenever the landlord gives you an advance notice that he wants to inspect the premises or that he wants to carry out repairs at a reasonable hour in the daytime, you must allow him. Number 5, obligation. You must not change or add to the structure without first obtaining the landlord's consent in writing. Number 6, you must not sublet your apartment without first obtaining the written consent of your landlord. Number 7, if the building has any structural or substantial damage, you must notify your landlord as soon as possible. Those are your legal obligations to your landlord as a tenant. Now, let's talk about your landlord's obligations to you as a tenant. Number 1, he must not disturb your quiet and peaceable enjoyment of the apartment. I shall talk more on this in the next topic. Number 2, he must pay all the rates and charges as stipulated by law. This obviously includes the tenement rates and the land use charges. Now, let me clarify this issue of tenement rates and land use charges before I go on. When I first published the book Know Your Right as a Tenant in 2006, many landlords and tenants kept asking me questions about rates and charges, particularly about tenement rates. That is, who has the responsibility to pay tenement rates? This is because many landlords are in the habit of passing tenement rates to their tenants. And I have also continually replied that I am not aware of any law which stipulates that tenement rates or land use charges must be paid by tenants. No. Secondly, I am aware that the demand notices for these rates are usually issued in the name of the landlord or landlady and not that of the tenants or occupiers. It is only when the landlord is not known or does not occupy the premises that the tenants may be required to pay. But even at that, the Land Use Charge Law of Lagos State 2001 provides that if a tenant pays the land use charges on behalf of the landlord, that tenant is entitled to deduct this payment against his next payment of rent. So says the law. In addition to this, I'm equally aware that the receipt for tenement rates or land use charges are some of the documents that can be relied upon in additional proof of ownership. And the Tenancy Law of Lagos State 2011 has clearly established it that landlords have an obligation to pay the rents or charges stipulated by law. Mind you, tenement rate is stipulated by law. So when next your landlord requests you to pay tenement rates, please point this out to him that it is his duty under the law to pay tenement rates. Number 3 obligation of your landlord. Your landlord is to insure the premises against loss or damage. Number 4, he must not stop you or restrict you from using the common facilities in the premises. Like I mentioned earlier, these common facilities include the kitchens, the toilets, the entrance, the veranda, balconies, stairway, and etc. Number 5, your landlord must not seize any of your items or properties, even if you owe rent. He must not also interfere with your access to your personal property. Number 6, your landlord is under the obligation to maintain the external and common parts of the building. He is also to effect repairs to these areas. Now, if you occupy a commercial or business premises, there is an additional set of rules. Under the tenancy law of Lagos State 2011, it is presumed to be part of your tenancy agreement that your landlord must compensate you if he has done anything that substantially affects the free flow of your customers into the premises, or where he has disturbed or hindered your access to the premises in a substantial manner, or where he fails to remove any obstruction in the premises that is causing you profit losses, or where he has failed to maintain the exterior or common parts of the building after you gave him written notice to do so, and you have to spend your money to do it. In these 4 instances, you are entitled to compensation from your landlord. The reasonable rate of your compensation will be fixed by the court upon application. So, in all of the situations I've just mentioned, the landlord and tenant's obligations to one another have been set out respectively. But let me point it out to you that all the above obligations are subject to the tenancy agreement between you and your landlord. So, if you had agreed with your landlord that he is free from all or some of these obligations, so be it. You cannot come back to enforce any of these obligations against him anymore. It is the same vice versa. Well, I have just told you what the law says about obligations of the landlord and tenants under the tenancy law of Lagos State 2011. But if there's no such provision in the law of your state, it doesn't mean that these obligations do not exist. No. The obligations of the landlord and tenant exist all over Nigeria, whether stipulated in any law or not. This is the law. Ladies and gentlemen, here I come to the end of our discussion on this chapter. But let me round up by refreshing your mind about the most important points to note. Number 1, you are entitled to basic amenities in the apartment like water, electricity, good ventilation, etc. Number 2, you are also entitled to standard rooms and kitchens. Number 3, you are entitled to negotiate the rent payable by you based upon the amenities present or absent in your apartment. Number 4, you are entitled to report to the sanitary department in your local government area where your environment is being dirtied or messed up by others or it lacks good sanitation. Number 5, you are also entitled to report to the appropriate authority where you suspect that the building is weak or that the building is sinking or that it may likely collapse. Number 6, remember that you have legal obligations to your landlord just the same way your landlord has legal obligations to you. Number 7, your landlord or caretaker is not entitled to disconnect power or water supply to your apartment. It is illegal. Number 8, if your landlord or caretaker disconnects power or water supply to your apartment, you are entitled to sue him. Now let's go to the next topic, and this is on chapter 2, where we'll be talking about your right to quiet and peaceable enjoyment of your apartment. Your right to quiet and peaceable enjoyment of your apartment. Let me inform you that under the law, the tenant enjoys certain rights by virtue of his tenancy. I shall enumerate these rights as follows. Number 1, your right to peaceable enjoyment of your apartment. I have spoken about your right to peaceable enjoyment of your apartment before, but let me just add that once the issue of your tenancy has been resolved and you have paid and moved in, you as the tenant, whether old or new, you have legally recognized rights over the apartment that you occupy. Hence, you are entitled not to be disturbed in your apartment by the landlord or his agent or any person claiming or acting on their behalf. Under the law, you are regarded as a bona fide occupier of the apartment who has a right against any person that trespasses on the apartment, including, of course, your landlord. Number 2, you have a right to privacy. Right to privacy. By virtue of your tenancy, your right to absolute privacy is equally guaranteed. Hence, your landlord does not have the right to enter your apartment without your knowledge, without your consent and without your authority. Where he does that, you are entitled to take the necessary legal actions to enforce your rights. It does not matter whether you occupy a room or a flat or a duplex. The same principles apply whether it is a residential, industrial, or commercial premises. And it is the same principle all over Nigeria. Your landlord does not have the right to enter your apartment or your property without your knowledge and consent. It is equally wrong for the landlord to remove the doors or roofing sheets over your apartment for whatever reasons without your knowledge. Some landlords believe that they have absolute rights to the apartment, and even when their intentions are genuine, for instance, maybe they want to remove the roof because it needs to be changed, they just do it without informing the tenant. This is wrong. The tenant is entitled to be informed where repairs are to be undertaken which may affect his right to privacy. This is because removing the roofing sheet or doors or windows can expose the tenant's properties to unnecessary risk. In the course of my practice as a lawyer, I have also witnessed situations where a landlord wakes up one day and tells his tenant to move from apartment A to apartment B. It could be because the landlord wants to convert apartment A from a room to a room and a parlor, or from a room to a shop, or from a residential flat to an office space. At times, the landlord may claim that he needs this property for his personal use. Let me inform you that, as the tenant, you are not obliged to accept this request. This is because what you paid for is apartment A, and for which you must enjoy the security of your tenancy. So, you are not under any legal obligation to agree to change your apartment for another one. The only exception here is, of course, if the landlord had previously informed you before you moved in that you will later change your apartment and you agreed to it. Furthermore, you may want to consider this request if you have a smooth relationship with your landlord or you don't mind the inconvenience. Now, talking about privacy, please note that the landlord or his agent is entitled to inspect the apartment so long as he has given you sufficient notice in advance. This inspection is primarily for the purpose of checking the state and condition of the apartment just to confirm that it is not being damaged by your use and to confirm that you are not going contrary to the tenancy agreement. But of course, these two can only be an occasional event, maybe about once in a month or thereabout. The landlord may also inspect where he has reasonable suspicion or sufficient information that an illegal act is being carried out in the premises. For instance, if a tenant has converted his residential apartment into a hideout for criminals, or he uses his apartment as a depot for keeping illegal arms and ammunition, or if he has turned the apartment into a brothel, in these instances of crime or illegality, the landlord is entitled to inspect with or without giving an advance notice. This is the law. Number 3. Your number 3 right as a tenant, you have the right to the security of your tenancy. This is another right guaranteed under the law. This means that once you have paid your rent for the month or for the year, as the case may be, your tenancy for that 1 month or 1 year is guaranteed. Your landlord is not allowed to arbitrarily terminate your tenancy within that period that you have paid for. If he wants to terminate your tenancy, he must give you a quick notice that will coincide with the end of your tenancy or that will terminate after the period you have paid for. The quick notice must not be short, even by a single day. For example, if you let an apartment under a yearly tenancy from January to December and you have duly paid for the whole year, your landlord cannot come in March to ask you to vacate the apartment in June or in October. If he wants you to leave, he must wait till the expiration of your tenancy in December. Of course, this does not mean that your landlord cannot give you notice to quit before your payment has expired. but the notice must not cut short your tenancy. This is the general rule. We shall discuss this issue of quit notice in more details in volume 3 of our lectures. But let me add this exception very, very quickly. Your landlord may terminate or cut short your tenancy halfway if you have done anything illegal, criminal, or contrary to the tenancy agreement. Remember I said it before that a tenancy agreement is a contract between you and your landlord, and that you are obliged to comply with these contract provisions as a tenant. If you go contrary to this tenancy agreement, it is a breach of agreement, and your landlord is entitled to terminate your tenancy, even when your rent has not expired. We will talk more about this in volume 3. Again, security of tenancy also means that your landlord must follow the laid-down procedure if he wants to eject you. Your landlord is not permitted to take the laws into his own hands by trying to force you out of the apartment or trying to forcefully eject you. He must follow the procedure as stipulated by law, and this means he must give you adequate quit notice and go to court to obtain judgment. He is not entitled to forcefully eject you or throw out your properties or lock you out, even if you have done anything contrary to the tenancy agreement. He must still follow the law by giving you the required notice. This is the law. Then number 4, what are your rights with your co-tenants and neighbors? In relation to your co-tenants and neighbors, you are also guaranteed absolute rights as far as your apartment is concerned. These rights include right to privacy, which I have mentioned above, right to peaceful enjoyment of your tenancy, and etc. Hence, you are entitled to raise objections where your peace is being disturbed unnecessarily by your co-tenant, for example, through excessive high volume of his sound systems. In relation to your rights with your co-tenants and neighbors, let me speak on this particular and growing trend nowadays. This is where co-tenants or neighbors indulge in night vigils or loud prayer sessions late at night, most especially from 12 midnight in residential apartments. In most cases, these night vigils are done with bells, with tambourines, and clapping, and at times with drumming and loud singing. This causes so much noise in residential apartments that is not appropriate. Those kind of happenings are meant for the religious houses and not for dwelling places. Even for religious organizations, let me inform you briefly that it is not appropriate for a church or mosque to hold night vigils and then use sound systems with external loudspeakers which broadcast sound throughout the neighborhood in the middle of the night and disturb other people's peace. True, there is freedom of religion, there is freedom of worship, and there is freedom of expression. But you cannot create inconveniences for another person just because you want to exercise your own right of freedom of worship or religion or expression. That other person has his own rights and freedoms which are guaranteed by the Constitution as well. Please note that some other person's right starts where your own right ends. Such noise constitutes public nuisance for which the residents are entitled to some remedies under the law. Anyway, I have dealt more elaborately with the issues of public and private nuisance in my other lecture series titled Know Your Civil Rights Against Other People. Know your civil rights against other people. But as far as tenancy matters are concerned, all tenants must be careful. They must be cautious and wary and not trample on another tenant's right just because they want to exercise their own right. Again, these days, the poor power situation has turned virtually every tenant in Nigeria into an independent power producer. Each tenant and apartment has been forced to acquire generators to provide light. And in many situations, some of these generators are substandard and they produce more noise than light. What happens if your co-tenant installs his generator in a place so close to your apartment and where the noise or smoke from the generator disturbs your peace? You are entitled to raise objections and make him see reasons why he needs to relocate such a generator. Where he refuses to adjust, Then you may lodge a complaint with your landlord to have the matter resolved. If he still fails to do the needful, you may then contact your lawyer for the appropriate legal steps. This is because you are entitled to your peace by virtue of the tenancy. Let me inform you also that you are entitled to complain if your co-tenants indulge in criminal or illegal activities in their apartment, maybe for instance, where your co-tenants harbor a notorious armed robber or a wanted person in his apartment. You can equally complain where the apartment is used for criminal activities, for example, where females are habitually raped or abused, or where, for instance, the apartment is used for the production of fake or adulterated products. It is your right to draw your landlord's attention to these illegalities, and where he fails to take action, you may inform the appropriate security agencies or authorities. If you don't report, you may be affected by the punishment that will result. For example, if the building is sealed or locked up by the government because of these illegalities, you may be affected even though you were not a partaker in these criminalities. This also applies in the case of your neighbors. You have the right to report any criminal activities going on in your neighbor's compound or in your street. It is wrong for other people to attack you for making such reports or to label you as police informant. In fact, it is one of your civic duties as a responsible citizen to report crime to the appropriate authorities. Don't be afraid of doing this. Peaceful enjoyment of your tenancy also applies where you have troublesome neighbors. You are entitled to complain if you find yourself living on the same floor or near some other tenants who are always fighting or disturbing the peace of the whole house. I must inform you that all the rights I have mentioned here are not just hearsay. They apply all over Nigeria. But particularly in Lagos State, the Tenancy Law of 2011 has made further specific provisions to confirm what I have just told you about your rights to quiet enjoyment of your apartment. This law expressly provides that as a tenant, you are entitled to a quiet and peaceful enjoyment of the premises you occupy. That law again says that these rights include the right to your privacy, the right of freedom from unreasonable disturbance, your right to your exclusive possession of the premises unless the landlord or his agent has informed you in advance that he wants to inspect, and then the right to use the common areas of the property for reasonable and lawful purposes. You are entitled to these rights even if you are in arrears of rent. This is the law. If you find your rights being infringed upon in any of the situations I have just mentioned in this chapter, please do not take the laws into your own hands. You are advised to contact your lawyer immediately, and he will advise you on the proper legal steps to be taken. Well, here we shall end our discussions on this chapter, but let me just refresh your mind about the most important notes as follows. Number 1, you are entitled to absolute privacy in your apartment. Number 2, though your landlord is entitled to inspect your apartment, he must do so with your knowledge and with advance notice. Number 3, you are entitled to the security of your tenants and not to be ejected without lawful processes, whether you occupy a room, a flat, or a whole house. Number 4, you are entitled to sound sleep, free from noisy night vigils or prayer sessions in the premises. Number 5, you are entitled to alert the relevant security agencies if you observe that illegal or criminal activities are going on in your co-tenant's apartment or in your neighbor's premises or even in your neighborhood. It is your civic responsibility. Number 6, the Lagos State Tenancy Law of 2011 has also confirmed that you have your right to quiet and peaceful enjoyment of the apartment you occupy. Number 7, do not take laws into your hands. If any of your rights is being infringed upon, please contact your lawyer. Now, let's move on to the next chapter of this lecture. Here in this chapter 3, I shall deal with important topics like arrears of rent, renovations, and nature of tenancy. arrears of rent, renovations, and nature of tenancy. These three issues are very important when it comes to landlord and tenant matters. I shall therefore deal with them one after the other. Now, on arrears of rent. To be a good tenant, you are required to pay your rent regularly. If you pay monthly as a monthly tenant, please make sure you pay your rent within the first few days of the new month. If you are a yearly tenant, then pay your rent in accordance with the tenancy agreement between you and the landlord. The agreement may specify that your rent for the year is to be paid in advance or in arrears, but in most instances, yearly payments are almost always in advance. But don't forget to demand for your rent receipt immediately after payment. Arrears of rent is not to be encouraged. Like I said earlier, rent is the basis of your right as a tenant. So, where you have failed or neglected to pay your rent as at when due, you have made it difficult for yourself to enforce some of these rights. Arrears of rent is also one of the reasons why your landlord can eject you. You can hardly escape if you are caught up in this. This is because most tenancy agreements contain provisions which forbid being in arrears of rent. Secondly, the law also frowns upon a tenant owing rent. For instance, in most states of Nigeria, if you are a monthly tenant and you are in arrears of rent for 3 months or more, then you have forfeited your right to a quit notice. If your landlord wants to eject you, he will only give you a 7-day notice, at the expiration of which he may apply to the court for a summons to eject you. I will talk more about this in volume 3. Let me give this information to tenants in Lagos, which they may not be aware of before now. Under the Lagos State Tenancy Laws of 2011, there is this unique provision which will put a tenant who is in arrears of rent in a very difficult position. This law relates to tenants who pay monthly, quarterly, or half-yearly. Now, this law says that if you are a monthly tenant and you are in arrears of rent for 6 months or more, then your tenancy will automatically terminate. Your tenancy will automatically terminate. What this means is that once you are a monthly tenant and you are in arrears of rent for 6 months and above, your tenancy has automatically terminated. It doesn't follow that your landlord or caretaker must inform you of this. It is automatic. It doesn't matter that your landlord or caretaker has not given you a quit notice. No. As a matter of fact, you have forfeited your right to quit notice. Your landlord or caretaker will merely give you 7 days notice and then approach the court for an order of possession and for the arrears of rent. This situation is similar in the case of a quarterly tenant or a half-yearly tenant. Once the tenant is in arrears of rent for 1 year or more, then the tenancy automatically terminates and the tenant has forfeited his right to quit notice. The landlord can simply go to court to obtain an order for possession and for the arrears of rent. You can see now that it is not advisable to be in arrears of rent. Please guard against it. Now, let me ask you this question. Are you to continue paying your rent after your landlord has given you a quit notice? My answer to this question is a capital yes. I will explain. Because this is another sore point between tenants and their landlords, mainly because people do not understand and mainly out of ignorance of the law. There is this common belief that once your landlord has given you a quit notice, then he is no more entitled to collect rent. This is not so. Even after the landlord has given you a quit notice, it is your legal obligation to pay your rent up till your very last day in the apartment. Up till your very last day in the apartment. There is no free accommodation anywhere in Nigeria. This is the law. But it happens at times that your landlord or caretaker, after issuing you with a quit notice, may tell you that he is no more interested in your rent, but for you to leave the house. Some tell you to vacate, even with all the arrears you owe, and use it to obtain another apartment elsewhere. This is a tricky situation, and my advice on this is as follows. If you are really prepared to leave and you are sure of vacating on a particular date, then you may enter into an agreement with your landlord or the agent on the arrears of rent. If he says he is prepared to waive the arrears of rent, let there be a written document to that effect from your landlord or agent, even if it's just a note on a piece of paper. This is because if you hold before you vacate, the landlord is still entitled to claim these arrears of rent even after you have vacated, so long as he knows where you are. The arrears of rent becomes a debt, which he is entitled to claim at any time within a maximum period of 6 years. I have witnessed a situation where a tenant who was in arrears of rent vacated an apartment 2 or 3 years ago and moved into a new one. And then the former landlord comes to the new apartment with court bailiffs and court sheriffs and policemen to execute a judgment obtained for the arrears of rent incurred in the former apartment. You can best imagine the embarrassment and confusion such a tenant was thrown into. So, this is why you need to be very, very careful. If the amount you owe as rent is substantial and your landlord says he doesn't want your money but for you to leave, then ensure that there is a written document to that effect from the landlord. Like I said, it could be just a note on a piece of paper signed by your landlord. Otherwise, you might be caught unawares and thoroughly embarrassed in your new house by your former landlord or caretaker over the rent you owed before you left his house, particularly if both of you parted ways in disagreement. And, some landlords or agents could be very wicked and vengeful. Their intention might not really be to collect the rent you owe them in your former apartment, but because they want to embarrass you in your new apartment. So you need to be very smart about this. Now let's talk about rent increment. Rent increment. Let me tell you straight away that your landlord is entitled to increase the rent on the apartment you occupy. But again, there are procedures to be followed in doing this. Let me tell you the procedures as follows. Number 1, you are entitled to be given at least a month's notice in advance of such increment, unless it is otherwise stated in your tenancy agreement. This is why, before signing the agreement, it is important for you to agree with your landlord on the length of notice to be given you before any such increment can take place. Number 2, it is not sufficient for your landlord to inform you of the increment orally. It should be in writing. Number 3, your landlord is not entitled to increase your rent in the middle of a current term. Any increment must take place from your next payment of rent. Number 4, your landlord cannot increase the rent every year. Note, however, that there is no particular time frame or interval for increment of rent in Lagos. In practice, rents are usually increased in the interval of between 3 to 5 years, depending on the particular landlord. But it is better to have this point included in your tenancy agreement so that there won't be any argument on this. We had expected that the Lagos State Tenancy Law of 2011 would contain provision on the interval between rent increment. The former rent edict, popularly called Marwa Law, said that rent could only be increased after 3 years. Unfortunately, the new tenancy law of Lagos State is silent on this. Number 5, your landlord cannot increase the rent arbitrarily. Some landlords increase rent by 100% and at times by 200%. This is unreasonable. In reality, rent increment is normally between 20 to 50% within an average of 3 years interval. Number 6, the increment should be justifiable. The landlord must justify that the new rent being demanded is commensurate with what obtains in similar property in the same neighborhood and must also show that his apartment has such basic amenities commensurate with the new rent being demanded. If you believe that the rent being demanded by your landlord is not justifiable or too high, you are entitled to seek legal remedies or ask for time to vacate. Lastly, number 7, after your landlord has told you that he wants to increase the rent and has told you the new amount he wants, you are entitled to negotiate the increment with your landlord. This point is important because some landlords believe that whatever they say is final, and once they tell you the new rate they want, there's no going back, and it's either you pay or you pack out. This is not permissible. Remember again that a landlord-tenant relationship is a contractual one, and both parties are permitted under the law to enter into this contract without duress, force, intimidation, or undue influence. So, if your landlord increases the rent, you are entitled to negotiate. If there is no amicable resolution and you believe that the rent is too high for you, you may request that you be given sufficient time to look for another accommodation. If your request is refused, please contact your lawyer immediately for the necessary legal steps to be taken. Now, do you remember that I promised to keep a good news for you? Yes, this is it. The good news for tenants in Lagos State is that the Tenancy Law of 2011 has made a beautiful provision against unreasonable increases in rent. Under Section 37 of the law, a tenant is entitled to apply to court that a particular rent increment is unreasonable unless the increment was previously agreed upon. To enable the court to determine whether the rent is truly unreasonable, firstly, the court will hear evidence from both parties. Secondly, the court will compare the general level of rents in that locality or similar locality. And thirdly, the court will consider any special circumstances relating to the premises. Let me tell you that such special circumstances may include whether your apartment has the basic amenities as you have discussed before in chapter 1 of this lecture. So you see here again that the knowledge of what the basic amenities of your type of apartment are is very useful. If the court finds that the rent increment is truly unreasonable, then the court will make an order reducing the rent to a specific amount to be paid by the tenant. And, the additional good news is that the landlord cannot eject a tenant until the case of the increment is decided. This means that once you are in court on the case of unreasonable rent increment, your landlord is not entitled to eject you until the case is ended. This is to prevent some vengeful landlords who would have ejected their tenants for taking them to the court because of the rent increment. So, your landlord cannot eject you until that case of rent increment is terminated. This is the law. I dare say that in other states of Nigeria where there are no such specific laws on rent increment as in Lagos State, tenants are still entitled to approach a court of law if they believe that the rent increment is unreasonable or unjustified or arbitrary. The court will look at the facts of each case and take a decision appropriately. It does not follow that your state of residence has not made any specific law in this regard. The courts will decide the case under the common law. Let me go to the next topic, and this is on renovations undertaken by tenants. Renovations undertaken by tenants. This is another point that has caused so much argument between landlords and tenants. It happens occasionally where probably the apartment you intend to occupy has been badly damaged by the previous occupants, and you are not reasonably expected to occupy it without carrying out some major repairs. Or probably as an old tenant, the roof of your apartment leaks so much that you are required to undertake a change of virtually all the roofing sheets and planks. Or let us say, for instance, that there was a major damage to the building or to your apartment, maybe by a heavy storm or by fire, which of course was not your fault. And your landlord has refused or is reluctant to carry out the repairs. Or maybe you spent your home money to complete the structure with the consent of the landlord. In most situations, these repairs are usually done with the understanding that the amount spent on such renovations or repairs would be converted to rent in favor of the tenant. As a tenant, what is your right in this situation? Where you find yourself in this position, you are advised to be very careful. This is because after you might have spent heavy sums of money in conducting the renovations or repairs in the hope that your landlord will refund the cost or convert the expenses to rent, he may turn around to deny that such a thing ever happened. So, you are advised to sit with your landlord or his agent and have a thorough discussion on this issue before you start at all. Present your problems to the landlord and tell him the estimate of the cost you are about to incur in carrying out the renovations or repair works. If there are arguments or doubts on the actual cost of the repairs, then call in 3 different artisans who will inspect the damage and present their quotations. You and the landlord may then compare these quotations and settle for the most reasonable one. The landlord may equally decide to have his artisan do the job and you pay for the services. Do not object to this as far as you believe the job will be well executed. The bottom line is this: ensure that you both agree on the actual amount to be spent. Then prepare a written agreement specifying the work to be done and the amount to be spent. In this agreement, please make it very clear whether your landlord has agreed to refund the sum to you later on or to convert it to rent payments. But make sure he signs. It's important. Please make sure he signs. Then you are safe to carry out the renovations. Alternatively, let your landlord give you his consent in writing before you start the repairs. His consent in writing before you start the repairs. The third option is this: where you have both agreed on the work to be done as well as the amount to be spent, then you may carry out the renovations or repairs and then collect the rent receipt that will cover this amount. Well, I don't usually advise on this third option because some landlords could be very terrible and will deny you in the long run. If there is no written agreement before you did the renovations, but you had the consent of the landlord or his agent to do it, here is a way out for you. You may present the original copy of the estimate or receipt to your landlord and let him endorse it by putting his name, signature, and date. Then you can keep this copy very safely. The position of the law on this point generally is that without a previous written consent of your landlord or without an agreement to that effect, you as a tenant cannot make any claim for compensation for any renovation or repair works done by you. This principle is applied in various states of the Federation of Nigeria and to all categories of accommodation, be it commercial, residential, or otherwise. Under the Tenancy Law of 2011, the law has further helped tenants by providing that if a tenant obtained the consent of the landlord in writing before doing any renovations and the landlord later terminates this tenancy, then the tenant is entitled to claim compensation for the renovations when he's quitting the apartment. Please note again that the emphasis here is on the word written consent. Written consent of your landlord. Don't make the mistake of embarking upon major renovations in your apartment just because your landlord or agent gave you go-ahead verbally. It won't work. Some other tenants expend huge sums of money to construct apartments on behalf of the landlord on the understanding that the amount so spent will be converted to rent for a number of years. They do this without any written agreement between them, relying only on the receipts used in purchasing the building materials. In the long run, they start having problems with the landlord, who may deny that he ever had such an agreement with the tenant or ever agreed to such number of years. In other cases, ownership of the property may suddenly change, maybe through death or sale to another person. If the old owner does not affirm the agreement and in the absence of a written agreement, the new owner is not bound in any way to honor such transactions, and he may eject the tenant, notwithstanding that the tenant used his money to erect or complete the structures. So please be careful of this particular situation. You are warned as a tenant to beware lest you spend substantial amounts to complete or renovate your landlord's property, and in the long run, you turn out to be the loser for it. But please note, however, that the type of renovations I'm talking about here does not include those minor repair works which you are obliged to carry out on your apartment from time to time. These are repairs under what we normally call the fair wear and tear weather rule. That is, those repairs that are occasioned by your daily use of the apartment. You must carry out these minor repairs yourself. This is the law. Now, let me go to the last topic, which is on the issue of nature of tenancy. Nature of tenancy. The nature of tenancy refers to the type of your tenancy, that is, whether it is a weekly tenancy, a monthly tenancy, a quarterly tenancy, a half-yearly tenancy, or a yearly tenancy. The nature of your tenancy is a very important point which every tenant must know, because it forms the basic principle that will determine how many months' notice you should be given if your landlord wants to eject you. That is, whether he will give you 1 month, 3 months, or 6 months quit notice. We shall discuss fully on quit notice in the next volume 3. The nature of your tenancy is determined, firstly, by the tenancy agreement. Hence, if you have a tenancy agreement, please ensure that it is clearly stated what the nature of your tenancy is, or how many months quit notice you are entitled to. If there is no tenancy agreement, and I know this is usually the case with majority of tenants in Nigeria, the manner of paying your rent, especially your subsequent payments after the initial advance rent, will determine what the nature of your tenancy is. Because in practice, most property owners demand for 1 or 2 years initial rent. And after this initial payment, you may be asked to be paying monthly, quarterly, half-yearly, or yearly, as the case may be. Your mode of payment will therefore determine the nature of your tenancy. That is why it is important for you to insist that the period you paid for is indicated on your rent receipt. Now, let me list out the various types of nature of tenancy that are available. Number 1, weekly tenancy. This is the category of tenants who pay their rents weekly. This is usually the case in short-letting hostels or guest houses. Number 2, monthly tenancy. This is one of the common types of tenancy in Nigeria. If you pay your rent monthly, that makes you a monthly tenant. It does not matter whether you pay 2, 3, 4, 5, or 10 months in advance or in arrears. You remain a monthly tenant. Number 3, quarterly tenancy. This applies to the tenant who pays his rent every 3 months, in advance or in arrears. He is regarded as a quarterly tenant. Number 4, half-yearly tenancy. This is the category of tenants who pay their rents every 6 months, whether in advance or in arrears, depending on the agreement between the parties. Number 5, yearly tenancy. This is the category of tenants who pay rent every year. This is equally common, especially with flats, duplexes, and houses. Number 6, tenancy at will. Tenancy at will. This happens if you don't pay rent at all, but you live in the apartment with the permission of the owner. It may be that the landlord is a relation, a friend, or someone who decides to let you occupy his house without collecting rent from you. If this is your situation, you are a tenant at will. A tenant at will. It is important, however, that you must occupy the apartment with the express consent and knowledge of the landlord. Otherwise, you are a trespasser. This is the law. So, as I have said before, the nature of your tenancy is a point which you must know, because this is the factor that will determine the length of the quit notice which you are entitled to. But please note that this is subject to the tenancy agreement between you and your landlord. Whatever your tenancy agreement says, as per the quit notice, is binding on you, notwithstanding your manner of rent payment. Anyway, this is what we shall discuss fully in the next volume, which is volume 3. But let me just round up on this chapter by reminding you of the most important points as follows. Number 1, arrears of rent is not to be encouraged. You must pay your rent regularly for you to be able to enforce some of your rights as a tenant. Number 2, your landlord cannot increase your rent every year or arbitrarily or in the middle of a term which you had already paid for. Number 3, you are entitled to negotiate any rent increment with your landlord. It is not a decree. Number 4, you are entitled to approach the court if you believe the rent increment is not reasonable. Number 5, if your apartment or building is in need of substantial renovations or repairs, make sure you inform your landlord and obtain his consent in writing before you embark on the repairs. Number 6, you may complete constructions on the landlord's behalf, but he must give you his written consent. Number 7, if there's no consent in writing, make sure he signs the estimates for the repairs or gives you rent receipt to cover the expenses. Number 8, you must know the nature of your tenancy or have it specified in your tenancy agreement. Number 9, you are either a weekly tenant, a monthly tenant, a quarterly tenant, a half-yearly tenant, a yearly tenant, or a tenant at will. Number 10, the nature of your tenancy will determine the length of the quit notice which you are entitled to in the absence of a tenancy agreement. Well, ladies and gentlemen, this is where we shall end our lecture in this volume 2 of Know Your Rights as a Tenant. I believe you too must have benefited immensely from the topics we have discussed in this volume 2. But in volume 3, we shall talk about very important issues like quit notice. That is, when and how is your landlord permitted to give you a quit notice, and whether your landlord is entitled to backdate the quit notice howsoever. Then how and when must the quit notice be served on you, and what are your rights when your landlord serves you a quit notice. We shall also talk about court summons. That is, when and how can your landlord summon you to court? And I will tell you about the 15 things that you do as a tenant that can make your landlord eject you. Then I will also teach you about what happens if your landlord takes you to court and how to defend yourself in court. That is, what to say or do when you find yourself in court with your landlord. These and many more interesting topics make this volume 3 indispensable. I look forward to seeing you then. Thank you.
Announcement. Thank you, ladies and gentlemen, for listening to our lecture. Let me remind you that we also have other Know Your Rights lecture series for your education. Our complete Know Your Right lecture series include 1. Know Your Rights as a tenant. 2. Know Your Rights as a landlord. 3. Know Your Rights as an employee. 4. Know Your Rights against the police and in court in criminal matters. 5. Know your fundamental human rights under Nigerian Constitution. 6. Know your civil rights against other people. And 7. Know how and where to buy landed properties in Nigeria. Let me inform you too that all our Know Your Rights lecture series are available in audio and in printed book format. The audio and printed books are being distributed by Centurion Publishers. Telephone numbers 08179005593, 09032465647. Distributors are wanted nationwide. Let me further inform you that all I Know Your Right series lectures are also available in ebook format so that you can download them and read them on your smartphones, iPad, or tablets and laptops. Simply log into www.hebony.com. www.hebony.com. You can simply pay online and download the books instantly. The audios will also be available for download very soon. For more information, please visit www.hebony.com. That is www.hebony.com. Thank you.